with Haber. That's Martinez. How you doing, Ed?
You got it right. You got it right.
Yeah, I know. I'm learning. It only took 56 episodes. 6 tries, something like that. So today's episode is called The Assiduous Trial Preparation Insider's View. I guess we could start with defining assiduous, which is showing difference. And that's really what trial preparation is all about. You've heard the words of real estate. You know what they are?
Of real estate?
Location,
What?
location. Well, with trial preparation, the magic three words are preparation. And so what Ed and I are going to do is we're going to kind of talk you through how we trial prep, which actually begins during the initial consultation. One thing that we know going into any criminal case, well, two things that we know going into any criminal case are the experience is cataclysmic. It's earth-shattering. Most folks have never once, and if they have been through the system once, it's been for something very minor. But even the most minor have very serious consequences and can rattle people. So we know this going into it. Generally apprehensive, scared, and properly so. If they're not apprehensive, probably because they've been through the system enough times to understand it. And like anything else, listen, if you're a great swimmer, you're not going to be as freaked out as somebody who really doesn't know how to swim or isn't that comfortable in the water. One thing we know, but the second thing that we know going into it is 97% of this are resolved by way of not going to trial. In other words, percent of cases in state court actually go to trial in criminal court. Less than 2%, the overwhelming majority of cases are not going to be a trial for any of a bajillion. We could be here for ages talking about all of the possible reasons why, but most is issued or because the defense is able to put forth enough proof to have the state back away. It's very rare for us. I don't know, Ed, you may have a different experience than I, but it's a client who at the initial consultation says, I'm going to trial and I don't want to talk about anything. If anything, I usually hear the opposite from my clients saying, there's no way I'm going to trial. I always have to take the tact of saying, look, this is going to take some time. In my office, flexible, but our goal is to resolve misdemeanor cases within 60 days and felonies. Why is that our goal? Because the state can't keep up with that pace. That's like putting a field for every down. The defense cannot substitute players. The state generally can't keep up with us. Does it always happen that way? Does that always come to fruition? No. But when we go into idea is speed, right? And so if we're able to overwhelm the state with speed and preparation, we're going to be offered something that our client's going to like. But on the other hand, we don't know. So prepare.
There, right. And in keeping with the football analogy, there is a drawback, right? There's positives and negatives to everything. The negative is you may want them to substitute those players because they're just too good. In other words, the evidence against you, not the prosecutor, but the evidence against you is, a bunch of all pro linebackers and defensive linemen ready to take you out. And you might want to slow down a little bit and see if maybe some players will get substituted out. Maybe you can get better players on your offensive line. There's always a positive and a negative to everything you do. And one of them, if you've got them on their heels, you push, and go as fast as you can to get it to trial.
The other thing that I guess there's a third thing that we know going into every case, and that is cases, I suppose this applies to family or civil cases as well, but all criminal cases, meaning just because it looks like something today does not necessarily mean that's how it's going to look tomorrow. It can change at the drop of a dime in a criminal case. And that
in either direction.
True all the way. all the discovery is done, all the evidence is done, the jury's selected, and then all of a sudden a critical witness says something completely contrary to prior testimony or what you expected, or there's a surprise. So, things do happen at any time during the course of a criminal case. So we, keep that in our mind that things can and will change. But all of this is stuff that Ed and we do day in and day out, right? If a surgeon's performing surgery, they know, hey, it's an artery, right? So they're prepared for it. They've got their, little crimpers and whatever it is to deal with those types of reasonably foreseeable possibilities. Then there's things that, right? So we're always alert. But my point in starting this out was to suggest that on the lawyer side are looking at a much larger picture right from the outset. We begin this calculus. It's during the client consultation. Have they been through the system? Do they have priors? Somebody who's already been to prison and has a DC number, a case likely very differently than somebody who's never been in the system before. Does someone eligible for diversion? Even if you have a case that you can win, a lot of people aren't going to say no to it as a guaranteed victory, assuming that they don't get themselves bounced out, of course. So, in our minds that we're kind of contemplating during this process, and that's how we tend to establish what I like to call a litigation objective. So when we have that initial consult tested for, after we've reviewed the police reports, after we've given an analysis to them after we've spoken to you about the facts and circumstances of the case, after we've discussed what possible, we decide on a litigation objective. That is a goal, okay? To go back with you may decide that you want to run the ball to develop play action passing, hit a touchdown. That's the goal, right? So we may say, well, our goal here is to file because it's a stand your ground case. We may say our goal here is to try and exclude the DUI case where you blew. Our goal may be to try the case. You're a multi-time convicted felon who was caught in, right? And so we may say that there is no plea offer on the table that we're going to get, and we're going to get a sympathetic juror or find some way to beat this case.
And in some cases, and this is usually more with our clients who have a history, who have priors. Sometimes it's just a matter of the offer that the state makes is not worth it, right? Because I always tell my clients the hardest decision you're going to make is when you're looking, let's say, at a min-man of, let's say, 15 years, and the state makes you an offer, or even a 3-year min-man. Let's take an easy one, a 3-year min-man. You're looking at a 3-year min-man, day to day, 3 years in prison, and the state makes you an offer of 3 years probation or 6 months jail time with 3 months probation on top of that. That's a hard decision because if you go to trial and lose, you're looking at 3 years. If you take the plea, you're out in 8, 9, 10 months and you do some probation. Obviously, if they come back with a PTI or a withhold court cost, that's usually, if you've got priors, an easy decision to make because you're like, okay, I'm not even attempting to risk this. And if they come back with a 3-year min-man, 90% of the time, depending on your priors, the judge will probably not give you more than 3-year min-man, at least not in Dade County. And so why would you not risk going to trial? You got nothing to lose. So a lot of these factors go into what we're looking at. So when you come to see us, I'm sure Michael's like I am. I'm looking at your priors for many reasons. That's just one reason. If you've got a lot of priors, in my mind, I'm thinking, all right, the state is probably going to come at him with a 3-year min-man because he's got too many priors, or he's got no priors. The state has got to give me a good offer here, withhold court costs, something really, really sweet because this guy's got no priors. But if they come back with a 3-year min-man, we got nothing to lose. So let's be ready. And going back to your initial analogy of the hurry up offense, For me, the way I see it, Mike, and tell me if I'm wrong, we usually go into the first quarter just trying to see how they're going to come at us and what defense they've got. That's the discovery process. We want to discover what they're playing. But once we got them on the heels, we go full bore. Now, sometimes it's the natural speedies. Sometimes we can do in the date in Florida anyway, we can decide to go the whole game, normal speed, and then when we've got them on their heels and they can't breathe and they're sucking wind and they're tired, bam, follow speedy demand, and now we got them. So it's a lot more complicated than you guys can think. And I think, Mike, we've talked about this in prior shows. I always tell people a really good defense lawyer, any really good trial lawyer, sees the case like a game of chess. There are so many plays and so many moves I can make on this chessboard, but a lot of it is determined by the move they make. I make a move, then I got to wait to see what they're going to move. But you and I are ready for 15 different moves. We just got to wait to see which one's going to be best for the game that we're playing or the situation we're in. And that starts with the meetings.
You segue, which is no matter what we think up front. And again, we always identify and agree with my client to that litigation objective, whatever it may be. But that we don't always get what we want, like a good coach or smart quarterback, and we have a secondary and oftentimes even a tertiary litigation objective. So we line up, we know we want this. So it's like that you call one play, but you've got another play lined up in case there's don't like. You're ready. You don't have to take a timeout. You don't have to go to the sidelines. It's all there. So you've established the goal. The next step is you have to get into the discovery phase because disinformation. Now, there are some cases where you don't want to engage in discovery. To be honest, Ed, you'll remember, the infamous attorney who did not engaged in discovery in any case I ever saw. And I remember one time where I was in court discovery, and he physically handed it back to the judge and said, "Judge, I don't want this. I didn't ask for it more times than that, but I just happened to be there." But Cy Gare, Alav HaShalom, Cy, he didn't engage in discovery. He believed that he wanted to go right to trial off of AYS. Normally, we engage in discovery, and y'all who watch this show know that Ed and I, in terms of depositions, where Ed's more inclined to take them and I'm not. But either way, it doesn't much matter that some amount of discovery is required. You want to know what the state knows about your client. You want to do it. It's malpractice not to, in my opinion. And again, with due respect, you have to is going to bring in. You have to know what witnesses they're going to call. So I'm preparing a case today. It got continued the last time we were at a trial setting because when the state tendered the judge, so that you guys understand, when you actually appear for trial, nonsense, but you are set for trial and you appear for your trial day, you have to present the state, both the state and the defense has to present the court with a written list of witnesses that you intend to call and exhibits that you intend to try and introduce into evidence. Doesn't mean that you're going to call, going to try to, or actually get any of that stuff in, but you have to give it to the judge in advance because you've already gone through everything, as long as there's no surprises and there's nothing the other side hasn't seen before. And we'll get to that in a little while towards the end of the show, because that's kind of the end of the discovery process that allows you to get to the point, right? Because in the discovery perfect world is going to give you a list of every witness that they are aware of that has any knowledge of, important, whether they're an eyewitness, whether they're a character witness, whether they're simply, even the officer who just transported the guy to the jail who had nothing else to do with the case. Anybody, much less materially involved in the case, has to be disclosed.
Right.
all of the evidence, if there was any searches or seizures, if there's confidential informants, if there was electronic surveillance, everything needs to be disclosed. And then if you accept that from the state, then reciprocal responsibility to provide the state with anything that you wish to use. Now, if you
if I can interrupt briefly, Mike.
Go ahead.
Going. God rest his soul. Cy Garrett was a great guy. He was a very good lawyer, but he didn't like to engage in discovery, because if you do engage in discovery, then you have to, like Michael said, we have to turn over.
Right, where we were going.
And he didn't want to turn over anything he was thinking. However, and I'm not judging, I just disagree with that strategy that Cy did, because in keeping with the football analogy, that would be like saying I'm going to play a team and I have film accessible of what they like to do, but I don't want to see it. I don't want to know who their players are. So I don't want to know if they've got Tyreek Hill or some guy who could, their wide receivers, none of them run faster than a 4.5. I don't care. I don't want to know if it's Tom Brady or Ryan Tannehill that's their quarterback. I don't care. I disagree with that. But I do agree with this philosophy, if I may, just years ago when the Heat won that championship, when Dwayne Wade, I think, was in his second year, and we had Shaq. Shaq was older, and his backup center was Alonzo Mourning. We didn't have a great team, remember? Everybody was like, why is this team, how are we going to win this championship? We were actually in fourth place when we went into the playoffs. Pat Riley did something very interesting, which is how I address my depots. Pat Riley had no plays. He just played the game straight up. But the other teams were using scripted plays that they had against the Heat. What Riley was doing was he was engaging in depots, but he was very skillful at making sure they didn't know what was coming to the playoffs. And that's the only way that I agree with Michael. The only reason I take depots is because I've studied with people and I've learned how to take depots doing what Pat Riley did. I don't let them know anything that I have coming, but it's very difficult. You got to know how to do it. But I do it because I want to know what their plays are. But most lawyers don't. Most lawyers, when they take these depots, you're right, Mike, they give too much because they treat it as if it's a trial. And it is the last thing from a trial. Secondly, as we keep going, everything Michael and I are talking about, to me, a good trial lawyer, by the time he gets to trial, as you notice, at every step, Michael and I are very involved in what we're doing. By the time you get to trial, you don't even need notes. I always use this analogy. It's like telling my daughter a bedtime story. That's all the jury wants. The jury just wants to know what happened. I know Goldilocks and the Three Bears. I know it. I know that little bedtime story. Does it really matter if the house was red or blue? No. Story is what the jury wants to know. Why? Who broke into the house? What was she doing there? What did she do that was illegal or not? That's all they really want to know. So if we do the way Michael and I handle our cases with our clients, by the time we get to the trial, it's like telling a bedtime story. I know exactly where all the pitfalls are coming. I know exactly what they're going to argue. I don't need to look at my notes. I don't even like taking notes. And the jury sees it more genuine when they see that you're up there talking and you're just telling a story. Keep that in mind as we keep going through the show.
So this discovery process is critical. And one of the things that makes it easy, again, these are things that we talk about regularly in our shows, is as we receive discovery, forward button and sending it off to the client so they have it too. If they ever read it or not, look, water. But what they can't say is you didn't give it to them. And at some point, you really do need to discuss it with them, that being a plea. Again, Let's say your client's goal is, I had a client not too long ago. It was a possession of cocaine case. It was absolute clean as a whistle, Oceans. You could not have a more slam dunk case for the sole avenue that we had as a legal defense in that case would have been if there was no lab report available. And the client had multiple priors. He was already a convicted felon, his belt. And he basically said to me, look, all I want to do is not go to jail. I'll take paper, I'll take house arrest, I'll do whatever I need to do. I just don't want to do time I have to do local time. I don't want to go up the road. So again, a case shakeout, but clearly we had a goal, right? Avoid an incarcerative sentence. So ultimately from the state, that's a adjudication time served. Well, he's already a convicted killer. The only kicker that he's going to get is because it's a drug case, he's going to have a driver's license revocation. Shy of that, no probation, no jail time. That was exactly what the man wanted. And further discovery other than making sure they had a lab report. Because my one statement, take the chance that I plea you out to a case that they have no evidence. I need to at least verify that they've tested it, that they have a predicate to get it in. And if they do, then we explain that very simply to the prosecutor, who was extremely accommodating.
And here's another thing. To keep in mind when you're out there looking for an attorney. Number one is, Michael pointed out something we've talked about in other shows. It's really helpful to your lawyer for you to tell them what is your bottom line, what's your cutoff right there at the meeting as soon as you know, if you know. Don't think just because you tell your lawyer, like Michael's client, well, I don't want to do any jail time. The minute the prosecutor says probation, Michael's going to jump on it. That's not what we do. I don't know if it's because we believe in the system or we're just competitive by nature, but we're not just going to take the offer because it's good enough for you. Now, some lawyers might, because they just want to get the case off their desk and they don't charge you enough. Michael and I charge to do the work that we're going to do, which is fight for you to get your best.
Let me give another. It might be that the client's wishes are more important. Let's say it's a first DUI and it's uncomplicated. Here in Dade County, they're eligible for diversion. He comes to you and says, listen, just put me in the back on track program. I don't want to fight this case. I don't want to have any calling as quickly as possible. So I would say to a client like that, listen, I have no problem putting you into program, but at least let me look at the discovery. At least let you that the machine was properly calibrated and there's no motion to suppress that breath result. STs. At least let me make sure that your officer is not a rookie who's never done them before. At least the minimum amount of diligence to justify my being involved in the case. And so that when you take that BOT, that it was a pretty good call for you to do it. And
I'll be honest. I want to.
Go ahead.
I do. I'm sorry, Michael. You're breaking up a little bit, so I don't mean to interrupt you, but I'm not sure if you're done.
Go ahead.
To be honest with you, Michael, I'm not going to go as far as to say it's unethical for a lawyer to put his client, let's say, in a back on track or any kind of diversion program without looking at the discovery. But I think it's certainly irresponsible.
Well, let's say that let's take a possession case, Lynn, and they're offering your client diversion, and you don't have a lab report.
Right. No, it's horrible. Listen, let's stick with the football analogy. Taking a diversion program before we look at discovery would be like the opposing team coming and saying, hey, look, let's not even play the game. Let's just call it a tie. And then, because you never asked, well, can I look at your roster? You come to find out that they didn't even have 11 guys. They have 4 guys.
Right.
Which means at the end of the game, you would have won easily, handedly. You can't do that. And I've never had either a judge, to be honest with you, or a state attorney object to asking for more time to accept the diversion program.
Some places they do. For example, in Broward County, they just started for DUI. If you request discovery, you are ineligible for the program. You can only take the program, engage in discovery. How's that for stacking the deck?
Yeah, well, listen, I get it and so you guys understand that are watching. As a former prosecutor, I don't like it, but I understand it because it is their program. It's not something that's in the statute. It's not something that a court can even offer. The judge can't offer it. It's a program that the state is doing for some type of alternative resolution. And their position is, if you want to fight, then we're going to litigate. Either we negotiate or litigate. Negotiate, take the plea of diversion. You don't want the diversion, then I guess we're litigating. I get it. The reason I don't like it, and I'm not judging or blaming prosecutors in any county for it, is because it kind of flies in the face of what our criminal justice system is, right? Our criminal justice system, in the words of Ben Franklin, it's better 100 guilty men go free than one innocent man be wrongly prosecuted. You know, it's just it just smacks as going, flying in the face of what our system is. If you've got such a good DUI,
Right.
what do you care?
Now
Just let him.
you're being punished for looking at the case, but it's important for us to investigate in this. So this discovery process dovetails with defense investigation case. Sometimes the only defense case is attacking the state's case. You don't always have defense witness evidence that you can put forward. Sometimes all you have is to challenge what the state puts up there, ridicule it, show that the police didn't conduct a proper investigation, show that they didn't do everything, that they had made mistakes, or that there were inconsistencies with officers' testimony, show that this had a motive to get up there and tell the story. Sometimes that's all you have, but others put forward. So let's talk about, for just a moment, what I'm doing now, and it's not anything that's secret, because all of this. So the state makes an arrest of my client based solely upon, there's no corroborating evidence, which is fine. They're entitled. Police officers are entitled to probable cause. The judge reviews it. In this case, the judge rubber stamped it. The state, by filing the charges as they were, as the arrest was made, and I'm looking at the discovery, and I'm looking at the police reports, and I'm looking at the body worn camera, and the first body worn is the residential neighborhood. And I say to myself, today's day and age, there's some surveillance cameras. So I grab my investigator, we run out to the scene, and sure enough, we 1, 2, 3, 4, 5, 6 surveillance cameras on 3 houses where my client lives, where the incident occurred, right in front of his front door, and then another video right across the street. So there are all of these possible cameras there. Police didn't ask anybody, including my client or his mother, who were both present on the scene. Video cameras there. Would you mind if we take a look at that footage? Never did any of that. There are at least, in the body cam view, none of them are listed as witnesses. None of them are, and in none of the 28 minutes of body cam footage does the officer speak to any of those. For our case, all of that is reasonable doubt fodder, right? That's stuff to attack on in terms of what they didn't do, why they didn't do it, why is the jury being police only relying upon one person's word without going any further. But we go the next step, right? We list the investigator as a witness, and we have him take photographs and all the Ring doorbell videos, and we have him do what the cops should have done: knock on far after the fact. But he knocks on doors, and now we've got affidavits that investigator from each of these homeowners that says, yeah, all of those cameras were there on that date at that time. Cameras were working on that date at that time. No, nobody from the police or from the state attorney's office. And yes, had they asked, we'd have been very happy to give it to them because we're good citizens. So, case that's built through the discovery process by looking at the state's evidence, reasonable vulnerabilities. So we went out and conducted our own defense investigation and started to develop. And when you get that done, now you get to revisit that issue. So imagine if the litigation of just get me probation. That's all I want. Well,
Right.
But now we have a much better case. Different than it did when we had that first initial consultation, because we didn't know then what we know now. Amorphous, constantly changing scenario that you need to be aware we could have just as easily found no video. Or maybe we would have found homeowners that said, oh, yeah, I've seen what your client did. He brutalized that person, right? I mean, who knows what you might find? You don't know away, but in this particular case, it did. And once you get through this process, once you get through and defense investigation, you get to the next most critical phase, which is prepare, right? You have to, like Ed said, you have to have a story to tell. It may not matter whether the house have to have a story. I like to say it a little bit differently than Ed did. I like to tell my clients going to a trial is like going to a party. Or maybe it's not like going to a party, but it's not a party. In that, there are two types of people that go to parties. It's a general rule. If I invite Martinez to my party, and Martinez shows up empty-handed, walks in, drinks my beer, picks up a girl and leaves, I'm probably not going to invite Ed to my next party. Why? Because he did nothing. On the flip side of the coin, if I invite Martinez to my party and he shows up with a girl on hand, well, now he's a contributor. And I'm probably going to invite him back to my next party. Juries like the defense to bring something to the table, to court.
That's true.
They would love a Perry Mason moment, although I guess today's juries are younger than Perry Mason juries, but the concept is the same. They would love to have love the defense to get up there and get the witness to say, oh, okay, I lied, you're right, it was all a lie. But you have to have something. You've got to give them something. If you just go in there whining and presenting nothing, you're probably going to walk away with nothing.
Right. Right. And so what is it that you're bringing to the party in the trial? You're bringing the story. You're bringing, okay, this is what they said. But let me show you how, if you were looking at this story from the other side of the room, you would have seen something completely different. Because usually, hardly ever, correct me if I'm wrong, Mike, hardly ever do we go to trial on something where our story is night and day from what the state is saying. Because if that were true, in all fairness, the state would probably drop the charges. Let's be fair. But we are coming with the story of, okay, it's either, and I've always said this when I was a prosecutor, defenses usually boil down to two things. And I used to tailor my jury selection as a state attorney in preparation for these defenses. It's always not always, but most of the times, it's one of two defenses. Either it wasn't my client, but the guy who actually did it never shows up. So it's like the ghost. Well, I don't know who did it, but it wasn't my guy. So it's the ghost. Or it's the incredible story. Okay, I know it looks like my client's guilty of this, but let me tell you this unbelievably fascinating, incredible story of why it looks like he did it, but he actually didn't do it. It's usually those two, and that's it. So why not prepare for the story? One or the other. Either it wasn't my client, and this is why. Or, yeah, he did. It looks like he did it, but it really wasn't, and this is why. Either way, you're bringing something. So we prepare for all that. And I want to give a story, Mike, if I can, as briefly as I can, about the discovery process, even when the state has it. Many times, and I find more often than not, when the state has evidence that exonerates your client, if they know that your client's probably innocent and the victim's lying, I would say probably 99% of the time, the prosecutor is going to dismiss the case. But what happens sometimes, like in this case that I'm about to tell you, my client was charged with a battery against his wife and a battery against his child, threatening, intimidating, and grabbing both of them violently. When the police show up, they took photographs of his wife's arm, and it had a bruise on the arm. They claim that both the wife and the child both said that my client had physically attacked them. But I asked for the body-worn cameras. The offer, by the way, Michael, the offer with a withhold of adjudication and court costs, not even probation. Okay? Or maybe probation, but that's it with just a stay away order. I can't remember exactly, but it was a really great offer. And my client was willing to take it. I said, let me just get the discovery. So I get the body worn. The lead officer gets to the whole. It's a condo, so he's in the lobby, and they have a security guard in the lobby, young man, and he's doing his thing. And then I fast forward to where he calls the security over. He tells the manager, "Hey, did anybody actually see what happened?" And the manager says, "I didn't, but the security guard did." He says, "Security guard, what happened?" He says, "Oh, the guy came down. He was really pissed off. He was super loud. He was really aggressive." And he says, "Did he touch her?" And the security guard says, "No, I saw the whole thing. He never touched her or the kid." Then he goes and says, "Do you know anybody else?" He said, "I think the girl at the front desk also saw." He asked the girl at the front desk, same thing. He was aggressive. He was really loud. He was really pissed off. I told him, he was getting out of control. He needed to leave the lobby because he was being way too loud and aggressive. And he said, "But did he touch him?" And the girl says, "No, I saw the whole thing. He never touched either of them." Now I had to go and tell the prosecutor, "Go look at the body worn. I know you haven't had a chance to see this, but I've got two independent witnesses that say they saw the whole damn thing, and your victim's lying." Now, why did the officer file charges? It's a battery. Look at our battery shows. You'll understand that there's more going on when there's a battery that has nothing to do with the law. It has more to do with lawsuits. But at the end of the day, you've got to look at the discovery, and you've got to be ready to say, okay, now that I've seen everything, you can be calm and feel confident that this offer is probably the best idea to take because we've seen all the discovery. And that's part of our preparation.
So, what's important to remember is, again, many lawyers don't do this, but always am very conscientious of sending everything to the client in real time. And I try weekly or bi-weekly conversations, even if they're only a minute. That way, at least I know the client's still around. But I don't mind spending a little while with the client to make sure that they've gotten everything like body worn, because it's really important to us that the client be able to look at them, give you context. There are things that you don't understand because you weren't there. The camera's only focused. It's not getting the other 270 degrees. So, the more the client is aware, the more the client knows, the better an informed opinion. So when you have that client who starts from the outset that they're insisting on going to trial, through the discovery, this may not be such a good idea. Maybe we ought to try and see if we can mitigate or resolve by way of a negotiation. Conversely, you may wind up in a better situation, like the case I was talking about with the and all the people on the street that are visible from the body worn. So as you go through, the client understands, the better position you are to be able to address these issues at trial. But we're talking about trial cases here, because that's what this show is about, right? Trial preparation. So developed our theme. The next thing we do is we develop what's called a trial notebook. And a trial notebook is really a literal notebook that contains your strategy for the trial. It's got a little bit of everything. You're going to need to start figuring out what do I need. The first fundamental blail is you need the jury instructions for what your client is being charged with. Every single has a corresponding jury instruction for it. And the jury instruction tells you the elements that the state has. The judge is going to read to the jury, assuming that there's no directed verdict or judgment of acquittal, there's no summary resolution by the court. If the case makes it to a jury, the judge is going to read them.
And for us that do take depots, not a lot of lawyers do this. I've spoken to them, and it's a mistake. I look at the jury instructions before I take depots, because then I ask questions that are relevant to the elements.
Whether you take depots or not, you cannot give competent advice. Yourself do not understand what it is that you have to defend. Those jury instructions are clutch. I print them out in case. It's one of the first thing that goes into my file right next to the arrest report. Sometimes before by the state, even before arraignment, because I need to know. And as many times as I do them, it doesn't hundreds of DUIs, hundreds and hundreds of theft cases, hundreds and hundreds of drug possession cases out for each and every case. Why? Because that file is unique. And that file needs instructions in it. So that's the type of stuff that's going to go in the trial notebook, right? You're going to have the state's witnesses. You're going to have lists of all of your witnesses. When you're starting to gear the case up, issue subpoenas for those people, because you can't be in a position where you're assuming that just because they or disclose somebody or even subpoenaed somebody, that they're going to present that person in trial. It's not even just a rookie mistake, because it just happened to me at my last trial setting on the case that's going on. Arresting officer who wore the body cam in this case, who was responsible for absolutely everything, when the judge, she wasn't on it. And
Right.
I'm like looking around going, what, are you freaking kidding me? Now, I'm not a rookie, but it was a rookie mistake. I did not subpoena that officer because I didn't think there was any chance the state wasn't going to call her. Well, look at what happened. And now I had to put my tail between a rookie mistake, and I did not subpoena this officer. The state has absolutely every right not to call her, but I need her. Please give me a 2-week reset so that I can get this officer under subpoena. And the judge was accommodating and allowed. You don't want those pitfalls. You do it anyhow. If it's a witness that you may want, obviously, if you have defense witnesses, you put them under subpoena too. Even if it's a friend, what people get cold feet at the last minute. So you have to have that. You have to prepare all of your evidence. If you're going to introduce anything, be it a text message, of anything, a video, a Ring doorbell. Let's say that I got a Ring doorbell in this, but let's say I did. Well, actually, let's not even pretend I did, because what we did get was photographs of Ring doorbells. All of those are disclosed to the state. They're tendered to them, and they're listed in my trial, so that when we go to court for trial call, I can hand them to the clerk, and they'll be marked as exhibits, marked because I've already got them prearranged as to how I'm going to refer to them. Because as a lawyer, up there and say, hey, look at this picture. I have to identify it as a specific picture. I have to lay a predicate for to make sure that it's properly identified on the record in the event that there's an appeal. The appellate team pictures are we talking about? Go ahead, Ed.
Let me give you an example of a chess game, real world situation chess game. Michael's absolutely correct on witnesses and listing witnesses and whatnot, except what, Michael? What witness do we not need to list? Rebuttal witnesses, right? Rebuttal witnesses, briefly, is a witness that comes in to testify to say that what another witness said is a lie. Generally speaking, that's the simple way of putting it. There's a little more complex, but that's basically it. A rebuttal witness is somebody who's going to come in and say, the witness the state just put on lied. So you don't need to list it. The rationale is you don't expect anybody to lie under oath. So why would I have to list them? I thought they were going to tell the truth. Here's an example of a chess game and why I take depots. I take depots and I don't let the state know that I have a witness who witnessed everything. Now I take the witnesses, the state's witness depot, and I go through. And then what happened? And then what happened? And then what happened? And then what happened? And then this happened. Are you sure that's what happened? Because I already know what my witness is going to say. But they don't know I have a witness. Are you sure that's what happened? Yeah, I'm positive that's what happened. Couldn't have happened any other way? No. Okay. There's the chess game. State doesn't know I have this witness. If we end up going to trial, like Michael said, I'm not sure. We may not. But if we end up going to trial, when I bring in that rebuttal witness, they're not ready with their piece because they never saw that coming. So this is why I think if you look back at all our shows, one of the themes that I think carries over in all our shows, Mike, is how complicated what we do really is. If a good lawyer, a good trial lawyer is a good strategist, it truly is a chess game. And when we go up against a good prosecutor, if it's a good defense attorney, it's a master's game because they're ready for everything. I was ready for rebuttal witnesses when I was a prosecutor. I would make sure I get my witnesses. Are you sure that you're telling me the truth? No, I'm not going to get any surprises from the defense attorney, right? That's what happens when you really understand that this is a chess game. Go ahead, Mike.
We're preparing for trial now, and at this juncture, if we had motions to suppress or motions to dismiss or motions for statutory immunity or motions to strike or anything. They've already been litigated and ruled upon. But we still have all of our case law prepared to re-object to everything. Let's say that the court has made a ruling that we don't like. In evidence, they refuse to suppress it. Well, we need to renew that. We need to re-object to it every record for appeal. Again, a good trial lawyer is going to, we may be cocky, we may go into it, intending to win, but always in the back of my mind, I have to, in the event that we don't. So we're doing all of this stuff, all of that work is done, but look, is our case law. We have our objections ready. We have all of these things that we need to do of litigiable issues outlined and ready to go. Now, we know that there's stuff to pay, but you pretty much have a good feel after 30 years of what you're going to come up against. To now start focusing on what we call motions in limine, which are the final governance of the trial, and those are very trial specific, although there are general motions in limine in every case. Overall, each case will have its unique addressed and dealt with by the court on the day of trial to give all of the lawyers guidance, gives us guidance as to how we deal with our witnesses. So if we're going to call witnesses, we prepare them. I don't mean we give them a script like an actor who's perfectly prepare them in terms of knowing the types of questions that they can expect to get from us, the answers that we expect to hear, and most importantly, how they can expect the prosecutor during cross-examination. Depending upon the complexity of the case and the experience of the witness and the sensitivity of the witness, we may actually do where we will I will call in Martinez and say, Ed, play prosecutor. And we'll actually emanation of the client, where I direct, Ed throws as many objections out as he can. The flow of how sometimes prosecutors will try and just mess up by throwing in objections and throwing the timing off, if for no other reason.
By the way, I never liked that. I always thought it was unethical, but they do it. And it's not unethical.
It's not a one-sided street. So either way, the idea is you prepare your witnesses. Now, our client, if you're my client, you're going to have known absolutely everything before you ever went into that discovery. We will have discussed everything 6 ways from Sunday. And I don't know whether or not my client is going to testify. I will for whether or not I need him to. And if I think that there's really a chance that I'm going to need my client, I will. If I'm not sure, I will give them minor preparation. But you have to prepare the client, because at the end of the day, I can tell there's only 2 things in control of in a criminal case. And one of those 2 things is whether or not a client testifies. Client to testify, you cannot force your client not to testify. And whether you testify or you don't testify, before that happens, the judge is going to make you raise your hand and swear you in, place you under oath, and then my understanding is that you plan on testifying. Do you know that you have a right not to testify? Or conversely, testify, do you know that you have a right to testify? Why is the judge doing that? For the same reason that Ed and I are preserving objections on bad rulings that the court has made and re-objecting, because it's this CYM back with a client saying, well, I wanted to testify, but my lawyer wouldn't let me, when the judge is colloquy whether or not he's willingly, knowingly, and intentionally either testifying or choosing not to.
Right. And as you see, as we're talking about this, right, Michael has hinted at something. I don't know if you caught it. I think it was pretty direct, but let's make sure we clarify. Notice he says, I'm not sure if he's going to tell. We don't know. A good trial lawyer, I will never tell my client, you're going to testify. Well, I can't say never. Hardly ever will I say to my client, you're going to testify for sure. Because I don't know.
Listen, there are some to stand your ground hearing.
That's
It's
a
not
motion.
a trial, but
right.
Well, let's say you lose the motion, defense and trial. Your client's going to have to take the stand and testify.
Well, hold on, right? But and here again, Mike, let's be honest. If we're anticipating that at trial our only defense is self-defense, I'm going to tell my client, listen, you're probably going to have to testify. Right. But why do I say probably? Because I don't really know what happened. The state's case might fall apart so bad. It might be such a train wreck that by the time like, hey, we don't even need the self-defense here. This is a train.
That's our last point. So let's hold off on that one for a minute.
Right.
We're ready for trial. We've got our trial notebook. Everything's all set. All of the evidentiary issues have been worked out one way or another. They've all been resolved. We know what the state's possible evidence is. We don't know which way to call. So we have placed under subpoena any ones that we think are really necessary just in the event. We've got all of our ducks in a row. We've got all of our issues printed out. There's one more thing, and that is, identifying presentation and technology issues. Day and age, there's a lot of tech, and you may want to use charts or graphs. You may want to use them to introduce them into evidence. Let's say it may be that a text message is relevant. You may want to, let's say a Google map is relevant. You may want to blow it up on a poster board. Let's say a statute, you want to blow it up on a poster board. Go ahead.
Let's say that there's a video you want to introduce that has audio on it, but the audio is all in Spanish. Even if jurors speak Spanish, the court will not allow,
you have to have it
unless you have a written, translated transcript that you hand to the jury in the middle of the trial. They can't take it in with them, but they can follow along as you're presenting it. And that's good for two reasons. One is that's the law. So the judge won't even let you play it if it's in Spanish, even if you've got 3 jurors out of 6 that speak Spanish. The other one is, let's be honest, I'm a fluent Spanish speaker, but I've never taken a Spanish class in my life. And anybody who speaks Spanish will tell you every country has a different dialect and different inflections, and everything sounds different. So what if I'm sitting there and I'm listening and I think I heard this Venezuelan or Colombian or South American guy say X, but because of his inflection, he really said another word that sounds very similar. So this is all part of the preparation. We got to be ready for all these things that are happening.
So you've got the day of trial. You're ready to go. Here's
ready to go.
The last things that you got to do. You need to be bright-eyed, bushy-tailed, on time, and well-dressed. You need to have a trial box. There's things that I bring to the courtroom in my trial box, and they may sound ridiculous to you, but I bring comfort food, some kind of trail mix or something, because if I need a burst of energy, I have to scoop a handful of raisins and cashews in my mouth. I need to be prepared to do that.
Here's something that many people don't see because you see it on TV and you don't understand. Michael, how many times I've been in jury trials? I don't even know how many. Somewhere around 50, 100. I don't know. I can count on one hand how many times the judge has allowed me as the lawyer to actually get a 1-hour lunch. Most of the times I'm sitting right there because I got 15 minutes because they let the jury go to lunch while we're litigating other issues. And then I got to prep for the witness that's coming. But I have an hour bar and a drink or something because I got to eat while I'm sitting at my desk. You can't really have a time for lunch.
So what I do, and I'll give a shout out right now to my guy because I'm not above the shameless plug, but I order food from Bagel Bar East. I have Bagel Steve make me stuff, and I sync up the courtroom, and I pick it up at 7 o'clock in the morning, 7:15 in the morning, and I keep it in my trial box. I'm not taking the chance that the judge may only give me 15 minutes, and if the judge does only give me 15 minutes, not only that, but again, it's one less thing to worry about later. If the judge does give us a nice sandwich, and I've got time to relax, put my feet up, and start to prepare for the rest of the day.
Correct.
But there's other things. You need pens. You need backup markers. You need highlighters. You need sticky pads. A pad.
Different color. different color
I always
highlighters.
give them ad and stickies because I want my client to, I don't want him, pushing me and grabbing my attention. I said, listen, I need to focus, but I need you to focus too. Something, if you have a question, if you have a comment, if you have a concern, if you have a thought, write it down. And then when we have forget it. I won't be distracted in the moment. Nobody misses anything, right? So you want for you chargers, little things like chargers. I have a battery backup unit that I carry with me.
Yep.
So well, actually, I can show you.
Yeah, Michael's absolutely correct. These are all things that
It's a little bit larger than my. It's a little bit larger than my cell phone. Charge 4 laptops, 15 iPads, and 30 iPhones. So there, I don't have to fumble for an extension cord and a plug. It's literally right there in front of me. I take my, why? Because who knows? There may be a problem with one. I need to have, a backup. And that goes to what Ed was saying before, and it's kind of one of our last points is, right? Always be aware of Murphy's Law. Things can go wrong. They will prepare for them to go wrong. Also, you need to be a Darwinist, right? You have to be able, you cannot move with the, with the ebb and the flow of the trial. You're going to drown. If anything is ever going to go exactly the way that you want it, how and when you want it to go. It may break your best. That easy.
The best trial lawyers are guys who can adapt, and best trial lawyers are just like ducks. You know why they're like ducks, Michael? Because on the surface they look calm, cool, and collected, but under the water, when the shit hits the fan, those feet are going all over the place because you've got to get to where you got to get to, but you got to look calm. And one of the reasons why we have markers and pens and chargers and all these things is because the jury's looking at everything. I sometimes go on trials on misdemeanors where I got a file, this big, but I'll take a box. Why? Because the jury's impressed. The jury sees a box and thinks, wow, this guy's ready. When I get up and I object, they're like, oh, he's probably right because there's a lot of shit in that box. He knows what he's doing.
Well, it's a lot of tricks. But the last thing that I want to get to that's really maybe the most important component of it is monitoring and controlling the client's behavior. Because it's like having an aria and you're the diva if you're the defendant in a criminal court on you. And all you have to do is smirk once, make some snuggle gesture, give the jury that feeling that you're an asshole. Cook your goose quicker than you can say it. So it's very important that you make sure that the dynamic. I'm always concerned about how they dress. I'm concerned about how they appear. I had a client late for a trial call. That is just always a horrible thing. Why? I mean, not only does the judge in a foul mood, and you're already behind the 8 ball with the judge. So not only did this guy show up late, but wearing sunglasses. And the judge absolutely teed off on him. I mean, horribly, and maybe not so wrongfully so. It could have been more tactfully done, I think. But, really wrong because my client was way off base. Now, He was told repeatedly the instructions. So you have to stay on top of the client. And then the other thing that I like to do is always have a second counsel in the courtroom with you. Even if they're not sitting at the table and they're just sitting behind you. Preferably, you want to have, it's good to have the client in tactile contact with somebody while the other person is really, but if you need to, you have somebody sitting in the back to be able to tap you on the shoulder and make sure that you didn't miss any. That's, I think that's pretty much trial in a nutshell. Anything else you want to add?
Add one little piece of reality. So after all this, if we do our job well, the day of trial we show up, a lot of times the plea offer gets better because the state realizes, all right, they weren't bluffing. We were. They're ready. We probably should plead this out.
Other times the cases just blow up. Other times the state case just blows up for any of a billion reasons. A witness doesn't show, undercover sale of narcotics, sale to an undercover officer, and they talked about all the marked money, read off the bills. He had his own little photocopy of the bills, evidence. The state then pulled out the sealed evidence envelope, ripped it open, had him read off the serial numbers, completely different numbers. They screwed up the badge. They put the wrong mistrial. So you never know what's going to happen during the course of the case.
How about in misdemeanor cases? How many times in a misdemeanor case of, let's say, possession of marijuana or something like that, the cop shows up the day of trial and says, I couldn't find the evidence.
So you never know. The point is, be prepared for everything. Again, golden rule of real estate, right? Location, location, location. The golden rule of trial work, of litigation, preparation. Your lawyer can never over-prepare. The client can never over-prepare. But go with the flow. Don't be too stressed. You know, if you're too stressed, it's like a lion, like a hungry lion on the Serengeti, they will hone in on the injured antelope.
I think your analogy in this situation of football is perfect, because you can go into the game knowing what the other team's game plan is, but what does a good quarterback do? He audibles.
Adapt.
Relaxed. I don't care. Oh, look, they changed everything up. I got him because I was ready for that, and I got my audibles in place.
Lines is, if you wait until halftime to adjust, you right. So you know you got to be on top of everything. You got to be the reasons. You really need to have a good night's sleep. You need to be rested. You need to have food, medicine. If your client as well, or any of your witnesses, sometimes you have family members in the audience. You don't want somebody passing because of low sugar. It just creates a whole scene that's completely unnecessary and distracting. It's not to say emergencies don't happen. Of course they do. But we want to try and micromanage as much as we constant knowledge that we need to be prepared to Darwinistically adapt as is necessary. Buddy, for your patience, we've gone a little over the hour mark as usual. I apologize for that, but I do appreciate your next Monday. And what's the first Monday in December? The 5th. As far as our show, but I suppose we'll know when we know and not before. Let's hope Monday, December 5th for episode number 57. And until then, thank you all for uploaded to social media as soon as possible. Thank you to our producers, to Miami Community Newspapers. Links to the show that we will get up on social media right away. Thank you all again. Martinez, thank you very much. I'll let you guys week how our trial went this week.
Yep. Have a good one.